So dakta mtazamaji, kikao cha mahakama kuu kuhusiana na kesi iliyowasilishwa na naibu rais aliyebanduliwa mamlakani Rigathi Gachagua kinaendelea, japo kwa sasa kimechukua mapumziko ya muda mfupi kabla ya majaji kurejea kuendeleza kikao hicho. Mawakili wa naibu rais aliyeng'atuliwa Rigathi Gachagua wakitaka mahakama isiruhusu Kithure Kindiki kuapishwa kuwa naibu rais kutokana na kesi hiyo, na zaidi pia wakipinga kubanduliwa kwake Rigathi Gachagua. Karibu kwa taarifa za K24 saa moja. Mimi ni Daniel Kitua, anayefasiri katika meza yetu ya lugha ya ishara ni Bwana Clement Muli, lakini kwanza tupate vichoche hamu. Mahakama ya juu yahalalisha sheria ya fedha ya mwaka 2023 pamoja na makato ya ujenzi wa nyumba za bei nafuu. Profesa Kithure Kindiki sasa asubiri tu uamuzi wa majaji wa mahakama kuu kujua kama ataapishwa lini kama naibu rais.
Pata chakula ni ngumu. Mimi nakunywa tu uji na maji.
Kijana Henry Omondi asimulia masaibu yake ya kuwa mlemavu baada ya kupigwa na polisi wakati wa maandamano ya Gen Z huko Siaya.
We cannot allow femicide to become a normalized part of a society. Enough is enough.
We want to make sure that this actually does stop.
Viongozi tofauti pamoja na FIDA washinikiza idara ya upelelezi wa jinai DCI kukomesha mauaji ya vijana jike yanaongezeka humu nchini. Mahakama ya juu hapa jijini Nairobi imesema kuwa sheria ya fedha ya mwaka 2023 iko sawa kisheria na kikatiba. Uamuzi huo uliotolewa na majaji 7 wa mahakama ya juu wakiongozwa na Jaji Mkuu Martha Koome umeondoa baadhi ya sehemu za uamuzi wa awali wa mahakama ya rufaa ambao ulitangaza sheria hiyo kuwa batili. Hata hivyo, mahakama imeendelea kushikilia kuwa sehemu fulani ikiwemo marekebisho ya sheria ya barabara ya Kenya na sheria ya mali zisizodaiwa ni kinyume cha katiba. Brian Mwai ana maelezo kamili.
Serikali ya Kenya Kwanza na pigo kwa Wakenya baada ya mahakama ya juu kutupilia mbali uamuzi wa mahakama ya rufaa kuwa mchakato mzima wa sheria ya fedha ya mwaka 2023 ni kinyume na sheria. Jopo hilo la majaji 7 wakiongozwa na Jaji Mkuu Martha Koome limesema kuwa sheria hiyo haikukiuka katiba na kuwa umma ulihusishwa vilivyo. Uamuzi wa mahakama ya juu unakuja wakati ambapo mjadala kuhusu sheria ya fedha na ukiukaji wa katiba umekithiri nchini. Kesi hii iliyowasilishwa awali na wawakilishi mbalimbali katika mahakama kuu ililenga kushtumu mchakato wa kisheria uliotumika kupitisha sheria hiyo na kuhoji uhalali wake kikatiba. Wakosoaji walidai kwamba sheria hiyo haikujumuisha ushirikishwaji wa umma wa kutosha, ilikiuka katiba na kukosa kuhusisha bunge la seneti, na ilijumuisha vifungu ambavyo vilikuwa nje ya upeo wa mswada wa fedha. Mwanzoni, mahakama kuu na mahakama ya rufaa zilipata sehemu kadhaa za sheria hiyo kuwa batili, hasa zile zinazohusu marekebisho ya sheria ya barabara ya Kenya na sheria ya mali zisizodaiwa, lakini mahakama ya juu ilipinga baadhi ya maamuzi hayo, huku ikiruhusu baadhi ya vifungu vya sheria hiyo kuendelea kutumika. Mahakama ilisema kwamba ingawa bunge halihitajiki kutoa maelezo ya kina kuhusu kila mapendekezo ya umma inayokubali au kukataa, linapaswa kuhakikisha kuwa mchakato wa kisheria unajumuisha wananchi, na hivyo wananchi walihusishwa katika mchakato huu. Mahakama pia iligusia suala tata la kodi ya nyumba za bei nafuu ambalo limekuwa donda sugu nchini na kusema kuwa suala hilo limepitwa na wakati. Kufuatia uamuzi huo, sheria ya fedha ya mwaka 2023 inasalia kutumika, japo ni pigo kwa Wakenya. Kesi ya kuipinga sheria hiyo iliwasilishwa mahakamani na seneta wa Busia Okiya Omtata Okoiti na wengine, wakitaka mahakama isimamishe utumizi wa sheria hiyo, wakisema kwamba ilipitishwa bila ya kuzingatia katiba, hasa katika ushirikishwaji wa umma. Brian Amuai, K24, Nairobi.
Na waadhiri wa vyuo vikuu kote nchini wamegoma tena hii leo baada ya mkataba wa maelewano wa kurejea kazini kutotekelezwa. Muungano wa waadhiri wa vyuo vikuu WASU umewalaumu manaibu wakuu wa vyuo kwa kuingilia kati mchakato wa kutekeleza mkataba wa mwaka 2021-2025. Malalamiko yao yanahusisha kutokuongezewa kwa mishahara yao kwa kati ya 7% na 10%, kutowasilishwa kwa malipo yao kwa benki na ukosefu wa bima ya afya bora. Harith Chimea ana maelezo zaidi.
Madarasa yamesalia kimya. Baadhi ya wanafunzi hawajui wafanye nini. Kisa wahadhiri wa vyuo vikuu vya umma kote nchini wamegoma tena. Katika chuo kikuu cha Dedan Kimathi, wahadhiri walikusanyika wakiwa na mabango na waliimba nyimbo za kudai haki. Ilikuwa hali sawa na hiyo katika chuo kikuu cha Moi, Eldoret.
Have declared the strike officially launched.
Akiongea katika chuo kikuu cha teknolojia TUK jijini Nairobi, katibu mkuu wa muungano wa wahadhiri wa vyuo vikuu WASU Constantine Wasonga alieleza kukerwa na serikali kwa kupuuza utekelezwaji wa mkataba wa maelewano wa kurejea kazini, ilhali serikali iliapa kuongeza mishahara yao kwa kati ya 7% na 10%.
People are earning automatic annual increment to the tune of 8%. I have the data with me here. And what I'm talking about is from Salaries and Remuneration Commission. Who gave them those automatic annual increment that you pay our members? They are arrears. You have denied them for all those years.
Wahadhiri wameitaka serikali tekeleze mkataba wa mwaka 2021 mwaka 2025 kwa haraka, wakiapa hawatasitisha mgomo.
We are telling the Kenyan parents now that there is a strike nationwide. There will be a strike until I don't know, God knows who, when. Because I foresee us being on strike up to January. Parents should come for their children. They stay at home until their government, who is the principal sponsor of these students, is willing and able to pay.
Wamewakashifu manaibu wakuu wa vyuo vikuu kwa kusambaratisha utekelezwaji wa matakwa yao.
And they came up with a figure, in fact, 3 scenarios which we did not agree. 4.3 billion, 5 billion and 8.6 billion. When we were interrogating as to how they arrived at those, whether they were having in mind the return to work formula, they said that the government had given them 4.3 billion. And that is what they want us to work with. That was against the return to work formula. According to the return to work formula, 7%, 10% and 4% annual increment was costing the government 9.6 billion.
Katika chuo kikuu cha Moi Eldoret hakuja kuwa na shughuli za masomo kwa zaidi ya wiki mbili. Mgomo wa wahadhiri umeingia siku ya 67 sasa.
Wamepanga mipango zao, wamesema wanafungua shule tarehe 4 Novemba. Lakini kama sisi kama wafanyakazi, hakuna mtu amewahi kuja kutuapproach na kutuambia mnataka aje. Sisi tunaitisha 8.6 billion. Ili nitoleo kotini kama mfanyakazi, ili tulipiwe pension yetu ambaye ni 4.2 billion, ili tulipiwe madeni zote wenye tunadai Moi University.
So far, Moi University staff are owed over 9.5 billion before tomorrow. But as from tomorrow, because we are in another month, the money would have increased to 10 billion.
Baadhi ya malalamiko mengine ni kutokuongezwa kwa mishahara yao kati ya 7% na 10%, kutowasilishwa kwa malipo yao kwa benki na ukosefu wa bima ya afya bora. Harriet Chimea, K24.
Na mtazamaji, moja kwa moja sasa tunaelekea katika Mahakama Kuu Milimani Mahani, ambapo majaji wamerejea kikao cha kusikiliza kesi ya naibu rais aliyebanduliwa Rigathi Gachagua akipinga kubanduliwa kwake. Tusikize kinachoendelea.
Deeply erratic. It's also elastic. The test requires the exercise of discretion. So at paragraph 6 of the Peter Gatirau case, the Supreme Court decision, you will find the following words, which are very, very important in our case. And that's the point I wanted to make in the first instance. That the grant of conservatory orders should be guided by the inherent merits of the case, bearing in mind the public interest. Public interest has been argued by my colleague. I don't need to repeat it. The constitutional values and the proportionate magnitude and priority levels attributed to the relevant causes. That is where I want to focus my submission. The provisions of Article 23 and the paragraph 86 of the Peter Gatirau Munya case are supplemented by the provisions of Rule 3.2 of the Mutunga rules, which require you to apply the constitutional doctrine of proportionality in the grant of conservatory orders. So that, my Lord, it is a delicate balance. The court will be balancing the scales of justice to grant that remedy for conservatory orders. And there are factors then which you will consider when you are balancing the scale for the grant of these conservatory orders. And one of them is that you will have to look at the decision that is being challenged from a prima facie perspective. What is the decision that is being challenged in court? For purpose of laying basis for this doctrine of constitutional, the doctrine of proportionality from a constitutional angle. And then that will determine whether that remedy for conservatory orders is effective or not. Now, the first petitioner was impeached. The first petitioner was impeached on 5 major grounds. That is important for you to determine the effectiveness of the remedy and the prima facie case threshold. He was impeached on gross violation of the Constitution. On that limb, there were 3 grounds which were confirmed on gross violation of the Constitution. Secondly, the first petitioner was impeached on the ground that there are serious reasons to believe he's committed crimes under national law. In this case, crimes under the National Cohesion and Integration Act. And the last ground, he was impeached on gross misconduct. Now, in determining the effectiveness of this remedy, the petitioners are arguing that you issue conservatory orders that reinstate this person to office. And our position is that you cannot issue conservatory orders that reinstate this person back to office because of the reasons why he was impeached. So you have to examine the grounds for impeachment. Secondly, what is the decision that is before court? What is the decision that is before court? Have the petitioners amended their notice of motion application to reflect the grounds which they are not happy about. Because, my lord, we presume, my lady, that they are, of course, not complaining that the Senate dismissed some of the grounds. We presume that they are complaining about the decision of the Senate which is aggrieved to them. So which they are aggrieved. So, my lord, if you look at the motion, you will find particulars of matters which relate to allegations which the Senate dismissed. And they are laying that as a basis for the grant of conservatory orders. You will find dominantly material with respect to ground number 7, which the Senate dismissed. Then they are saying that is a basis for the grant of conservatory orders. And we are saying, my lord, to that extent, they have not completed the test in terms of putting an arguable case in court. They ought to have amended their pleadings to reflect the correct complaint which they have before court and which they ought to lay before court. Secondly, thirdly, in determining the threshold, in determining the arguability threshold, I just need to mention 2 decisions from the Supreme Court that you will have to consider. In determining whether they have a prima facie case, you will, of necessity, look at the decision of the Sonko, the Sonko judgment that has been famously described as the Sonko judgment. Now, this Sonko judgment contains principles when it comes to the threshold for all these 3 grounds that the Senate found to have been confirmed. So for purpose of determining an arguable case, the petitioners have not been granular. They have not complained for purpose of laying a basis with respect to these grounds on why, for example, when it comes to the question of threshold, are they complaining that these grounds don't meet the constitutional threshold? So I invite you to look at the case of Munya as well. And lastly, on the question of the grant of conservatory orders, the Kariuki Mate decision. There is a reason why the Supreme Court, in the Justice Kariuki Mate case, has asked the High Court to apply the doctrine of judicial restraint in granting ex parte orders. And we are arguing that if you look at that decision again, the same reasons why the Supreme Court informed the court not to grant conservatory orders with respect to active parliamentary proceedings. Those same reasons are available when you are determining the effectiveness of the remedy of conservatory orders. And it's our firm submission here that conservatory orders, if you look at the 4 corners of the Constitution, the provisions of Article 23, should not be granted in a manner that reinstates the impeached deputy president back to office. Because then what will be the purposes of granting that conservatory orders? He goes back to office, he's been impeached for violating national values and principles of governance. So where does the test lead to? We submit that the remedy for the grant of conservatory orders that reinstate is not available to them. The reason is that conservatory orders is a highly and ineffective remedy. Conservatory orders will mean then that this court intervenes on matters which are dominantly political. And in the Munya decision, there is a finding that you cannot intervene on matters which the Supreme Court has stated are supposed to be properly before the other arms of Parliament. It is only the Senate and the National Assembly, as it were in the first instance, that can determine the question of impeachment. Impeachment is about policy, political accountability, and governance responsibility. So to that extent, I wish to submit that the petitioners have not, in terms of the effectiveness of this remedy, laid before court enough material. And I wish to stop there and ask my colleague Mshemi to complete our other part of the submissions. Thank you.
My lords and my lady, my name is Michael Mushemi, appearing for the 9th respondent. On our part, we rely on 2 affidavits, one sworn on the 22nd of October, a supplementary affidavit sworn on the 27th of October, and submissions and list of authorities dated 27th of October. My lords and my lady, permit me to address you on 2 critical issues. One is the issue of public interest, and the second is the legal theory of realism as to why conservatory orders cannot issue, especially as to sustain the first petitioner in office as Deputy President. On the first issue of public interest, my lords and my lady, you have been told this morning by the petitioners that the office of the Deputy President can remain vacant for a period of even up to 60 days because there is no function that would not take place in government. It is our submission first, my lords and my lady, that the Deputy President is mandated to chair the Intergovernmental Budget and Economic Council, which is created by Article 6, subsection 2 of the Constitution and Section 187 of the Public Finance Management Act. And the Intergovernmental Budget and Economic Council coordinates government policies, legislation, and functions as between the national and county government. My lords and my lady, the law prescribes that the chair and convener of this council can only be the Deputy President. There is no other person in law that can convene the Intergovernmental Budget and Economic Council. Secondly, my lords and my lady, under Article 240 of the Constitution, there is established the National Security Council. And one of the members of the National Security Council is the Deputy President, and it is our submission that pursuant to Article 240 of the Constitution, there is no other person or holder of any other office who can substitute the Deputy President as a member of the National Security Council. This is important, my lords and my lady, because the National Security Council exercises supervisory control over national security organs. This is a critical function of the state. In the absence of the Deputy President, there is legitimate reason to believe that the National Security Council is not properly constituted. And again, this is important, my lords and my lady, because if you look at Article 240, subsection 8, the Council may, with the approval of Parliament, deploy national forces outside Kenya for either regional or international peace support operations or other support operations. So that the situation subsisting as at today, my lords and my lady, is that the National Security Council cannot deploy any national forces either for support operations within the country or international peace support operations. And I urge and respectfully submit to this court to take judicial notice that officers from the National Police Service are currently deployed in Haiti to support with peace operations. So that the argument by the petitioners that the office of the Deputy President can continue to remain vacant is not available because these two critical functions provided by the Constitution and law would not effectively be carried out. On the second issue, my lords and my lady, I invite you to look at Article 3 and Article 4 of the Constitution, and particularly Article 4, subsection 2, which states that the Republic of Kenya shall be a multi-party democratic state founded on the national values and principles of governance referred to in Article 10. The words used in this section are shall, which is mandatory, and the first petitioner avers in his supplementary affidavit, and I wish to draw your attention to his supplementary affidavit in paragraph 17. That is a supplementary affidavit dated the 27th of October 2024. And on oath, he avers on paragraph 17 that I observe that in other open and democratic societies, and he goes on to say, unlike Kenya. So the first petitioner is averring on oath that Kenya is neither an open nor a democratic society. That is his own affidavit. It is our submission that conservatory orders would militate against legal realism to reinstate a person who cannot safeguard the oath he took as deputy president, safeguard the Constitution, and who avers in open public that this country is not a democratic society. My lords and my lady, I also invite you to look at Article 130 and Article 131 of the Constitution, which provides that the head of state, the president is the head of state, and the deputy president deputizes him. And in the authority of the president as provided in Article 131, particularly subsection 2C and D, is to promote and enhance the unity of the nation and to promote respect for the diversity of the people and communities of Kenya. It is our humble submission that any grant of conservatory orders that would sustain the first petitioner in the office of Deputy President would be a violation of this article. It would also be a violation of Article 147, which provides that the Deputy President is the principal assistant to the President and shall deputize the President in execution of his functions. And why this is important is because in the supplementary affidavit dated the 27th of October, we have deponed, or the 9th respondent has deponed, and particularly in paragraph 16, several averments by the first petitioner in which he infers that the President is responsible and must be held to account if anything happens to him. And I will not indicate the rest. You will find them in the supplementary affidavit. So that, my lords and my lady, pursuant to Article 147, it is now no longer tenable that the first petitioner, either at the interlocutory stage or on the final orders of the petitioner, can continue to be the principal assistant to the President. My lords and my lady, I also draw your attention to Executive Order number 1 of 2023, which stipulates that the Deputy President shall chair cabinet committees and shall coordinate issues of budget and policy making of constitutional commissions and other independent offices. Our first submission is that as we speak, there is no person who can execute the function of chairing cabinet committees. On the issue of constitutional commissions and independent offices, it is our humble submission that the Senate, having found the first petitioner guilty of violation of Article 160, then he cannot coordinate any functions with the judiciary effectively. The final thing, my lords and my lady, I would wish you to look at is the issue of political parties, particularly the role they have in policy formulation, political mobilization, and political democratization under Article 4 of our Constitution. The first petitioner was impeached by the Senate by a supermajority, which included members of his own political party and coalition. And I would want to draw you to a comparative analysis. When you retire, you will look at impeachment processes, which we have deponed to in the USA, in South Africa, and Brazil. But of instructive to note that closer home in South Africa, when Thabo Mbeki lost confidence of his own party, he resigned in 2008. And when Jacob Zuma lost the confidence of his own party, he resigned in 2018. So we respectfully submit, on behalf of the 9th respondent, that because of those two issues, conservatory orders cannot issue in this matter. Thank you, my lords and my lady.
Thank you. Thank you very much, my lords and my lady. I want to take 2-3 minutes to delve into the reasons why we support the applications to set aside the conservatory orders, and pray that the applications for those conservatory orders be dismissed. My name is George Murugara, appearing with the team for the National Assembly of Kenya. I begin by drawing your attention to the provisions of Article 118 of the Constitution, which actually deals with the public participation, which has been debated on and argued on in the House. And what I wish to draw the attention of the court to is sub-article 1, paragraph B, where Parliament is mandated to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. What I wish to point out here is that not all business of the National Assembly or of Parliament has to undergo a public participation, because not all legislative duties nor other business actually does go through public participation. There are legislative processes in this country which need not be subjected to public participation, and also other business of the House which need not be subjected to public participation. What is important is the wording of that clause. The word "or" is not used, because if that was the intention, that everything that Parliament does has to undergo public participation, it would have been that in all legislative and in all other business of Parliament and its committees. However, I take you to Article 145, where there was public participation, in spite of the fact that there is no provision that there ought to have been public participation when the motion was actually moved. The correct position is that any member of the National Assembly, on attaining the threshold, can actually move a motion that the President or the Deputy President be impeached. Once that motion is moved, then it goes to chamber, it is debated, and it is voted on. So it is actually for Parliament to determine when to take such a motion for public participation. And I confirm that here, out of abundant caution, Parliament did take this motion to public participation on 2 days as was even ordered by the court. And after the public participation, there was debate on it in the Parliament. It is this debate that takes into account the public participation, the views that were collected from the public out there. Then after that, a vote was taken, and therefore that process cannot be faulted. It cannot be said to have been flawed in any way, because in spite of the fact that there was no requirement for public participation, it was done out of avalanche caution. Finally, there has been an argument that under Article 149, there ought to have been public participation regarding the nominee who was taken to the House for voting. And here we must draw the distinction drawn that this is not an approval. Approval on appointments comes under different articles of the Constitution. It's clearly provided that the appointment would be with approval of Parliament or approval of the National Assembly. Here, what took place was just a vote. There was no motion because there is no requirement for a motion. There was no debate because there was no requirement for a debate. Because what the law provides is the President nominates and the House votes. So the House sits, it's called to vote on the nominee on the basis that possibly the nominee is known to the entire country. And this is the reason why there is no public participation. If Parliament votes against that candidate, then the President would have to nominate another candidate and continue doing so within a span of 60 days until he gets a vote that is positive in his favor, not an approval. And we've said that approvals usually come under the Public Appointments Parliamentary Approval Act. This is the one that governs approval. This is the one which provides that there must be public participation in all public appointments when actually Parliament has to offer an approval. So finally, public participation here goes to Article number 1, where Parliament is exercising delegated powers of the sovereignty of the people of Kenya. It is presumed that when the Parliament votes, the candidate is known to the people of Kenya, and through their elected representatives, they have actually to cast votes which are in tandem with how their constituencies would have voted. So with these remarks, it is my submission that the nomination and the subsequent vote in his favor of Professor Kithure Kindiki was in order. It was actually appropriate, and it cannot be faulted in any way, and therefore those conservatory orders should be removed. Thank you very much.
Distinguished members of the bench, Mahat Somane. For the record, I do appear with Dr. Willie Mutubwa and Mr. Hassan Noura for the IEBC. They are all here. Dr. Willie Mutubwa and Mr. Hassan Noura. We are the 16th respondent. We are not with the other respondents. We are the IEBC. We are on our own, and to clarify matters to the court. Distinguished members of the bench, just for the record.
We hope that you are not sharing the minutes, these 5 minutes.
Your Lordship, it's just me. We are not sharing.
All right.
We've decided we will not distribute the time. I will try to cover as much ground as I can on the time allocated. If I need 1 or 2 minutes, you will be kind enough to add me, but I will try to cover. I know it's very late. Just for the record, we rely on the replying affidavit sworn on the 25th of October 2024 by Hussein Marjan Hussein, who is the CEO of the Commission. We rely on the written submissions dated 27th of October 2024 in response to the various petitions and the applications. We rely also on the written submissions dated 27th October 2024 with regard to the application for conservatory orders, as well as the bundles of the authorities. They are on record, Your Lordship, and we have filed and served the same. Your Lordship, on preliminary issues, it's good I came last because it was a learning experience for me, but also for preliminary issues. To the extent that a lot of the petitioners and even some aspect of the respondent dwelt on merit review of the petition, when this is an application for conservatory orders, those submissions should be disregarded by the court. That's the first one. The second aspect, even though the decision or the petitioners is an application for their rights in personam, the fact that the IEBC is here and this is a public interest matter, your decision will be a decision in rem. So the IEBC will be asking that you clarify for it the applicable principle and guide it on first principles. The third one, and which is very important, is it seems that there's a general agreement that the law that will apply, and this is the only thing that all the lawyers agreed on, is Munya. Peter Gatirao Munya is the standard for conservatory orders. We believe the court should adopt that standard. I will not dwell much on the prima facie case, but I will dwell a little bit on the negatory aspect as it relates to my client. My client has been bundled up into these proceedings to establish the application for conservatory orders on two grounds. And this is important for the court to note this, on two grounds. The first one, the petitioner say that the IEBC has a constitutional role in filling a vacancy in the office of Deputy President under Article 149 of the Constitution. And this is important. The second aspect, they say that even though they have a role, they cannot discharge that role because they do not have the constitutional and legal capacity to function, as they don't have commissioners. This is very interesting. This is what my professor at Harvard Law will call, Mark Kushner will call constitutional chaos. So they tell you there is a role to be played by the constitutional body. And then they say, once you establish there's a role to be played by the IEBC cannot play that role. Your Lordship, in Peter Gatirao Munya, and this is a point that has not been made by most of the council, the issue of conservatory orders is not for the benefit of the private or the public party. Conservatory orders is for the benefit of the court, because they are supposed to preserve adjudicatory capacity of the court. Just that. If a party benefits because of that, that is collateral. And that is really important for this court. Because once you establish it's for your adjudicatory capacity, two things fall away. The first thing that will fall away, if you find that there is a remedy, there is an alternative remedy in merit review when the petition is heard, there are remedies that subsist when the petition is heard, then that aspect falls away. The second aspect that will fall away, if you make a finding that there's a constitutional mandamus, and Your Lordship, I will refer to you to Article 145(7) of the Constitution. If you make a finding that there's a constitutional mandamus, injunction, edict, direction to the court, then you have to stop there. And Article 145(7) is in such mandatory terms that there is no other way that this court can interpret. X, the president shall cease to hold office. Constitutional injunction, mandamus. So if those two findings are made, then there is no way the petitioners can establish the negatory aspect. As relates to the two issues, the gravamen of dispute, the position of the IEBC is that the IEBC does not play any role as relates to vacancy through impeachment under Articles 99 and 137 of the Constitution. There is no constitutional role for the IEBC. There is no statutory role for the IEBC, and I'll come to that because we spent quite a bit of time, just like the predicament the court is in, whether it should intervene under 165, we also had that predicament. Is there a role for the IEBC? That is the question the CEO of the IEBC asked. And we came to the very considered conclusion, there is no role for us because of constitutional design. And I'll come to that constitutional design. Unlike the court, the IEBC has been involved in a lot of litigation against itself. And there is directions from the Supreme Court of the Republic on what IEBC can do and what IEBC cannot do. I want to refer the court to paragraph 13 of our submissions, the BBI case, the Supreme Court one. And IEBC here can be substituted also for this court, because this court is a creature of Chapter 10 of the Constitution. The IEBC is a creature of Chapter 15 of the Constitution. And this is what the Supreme Court says. At paragraph 13 of we've quoted it verbatim. Number one, the Supreme Court said, the IEBC, being a creature of Constitution and statute, could only discharge mandate vested in it explicitly by law. This court, being a creature of the Constitution and statute, can only discharge mandate vested in it explicitly by the law and the Constitution. The second one, which is very important for this court, is the court said that this was direction given under Article 10(2) of the Constitution and the aspects of rule of law under Article 10(2). The third point that the court made, the IEBC, like other public bodies, could not by craft of innovation, and this is really important, Supreme Court, the IEBC, like other public bodies, could not by craft of innovation or interpretation extend its powers. So it is sufficient for the IEBC or even for this court to look at the constitutive document, the Constitution, and the statutory law, and not get and exercise what is within the inner boundaries of that. And D, which is to this court, courts should not encourage extension of powers by constitutional or statutory bodies. And this is really important, paragraph 13 of our submissions, Your Lordship. So the constitution of my client IEBC is under Article 88(1), 253, and 259. The position of the IEBC relating to this matter is that Article 149, 145, 150 establish a complete self-contained code. It is a constitutional codified mechanism. It's not a statutory mechanism for governors, for members of National Assembly. It is a constitutional codified mechanism. So when this court is interpreting, IEBC is a creature of the Constitution. This process is a creature of the Constitution. You cannot get out of the Constitution for this process. This court is a creature of the Constitution. So as it relates to the nomination by the President, as it relates to the parliamentary vote, it is not envisaged there is an involvement of the IEBC. This is a constitutional mandamus. As against the IEBC, and I will say as against even this court. We also rely on the case of Engineer Geoffrey Sang versus the DPP and 20 others, your brother Justice Odunga, paragraph 18 of our submissions. And he says that the law is very clear that powers must be expressly conferred. They cannot be a matter of implication. You cannot imply powers. And this is the absurdity. If this court was to make a finding, for example, that IEBC has a role, the way IEBC conducts elections is known, or by-elections. So the second order question we'll be asking the court is, do we declare a by-election? Election by its nature is a contest. How will that contest of filling that office be had? Do we print ballot papers? Those are the secondary order questions that the absurdity of the finding of the court that IEBC has a role will entail to. The second thing, our position, is that this constitution is very detailed. It is very interesting. This constitution tells you how it should be interpreted under Article 10. It tells you under Article 201 how the principles of taxation that will apply. It has what we call constitutional carve-outs, the powers given to various entities. It will be high presupposition to assume that this constitution under 149 could have said that this process, it says for even members of National Assembly. It says for members of National Assembly, and even in the elections that we have that. For an office that is that high, there is, to say that the constitution could not have said that IEBC has a role or this court has a role will be a very grand supposition. Your Lordship, we looked at, so we asked the question, what the court should ask. If someone said IEBC has a role, we looked at the things that we will look at. So we'll say, what did the framers think? Can we look at constitutional history to say if there was a role for the IEBC? The IEBC looked at the Bomas draft, Article 168. It looked at the WACO draft, Article 159.1, and we looked at the Harmonas draft. And in all of them, there is no role for the IEBC. So even by constitutional history and constitutional design, there was no role for the IEBC. In fact, there was a role in the WACO draft for the Supreme Court, and those submissions have been made by Mr. Mudomi Tiankolu.
Thank you.
Your Lordship, just 1 minute, I'm almost winding up. Your Lordship, for you to, and then there's a second issue, and then the reason why the court should not interfere with this process, especially or find there's a role for IEBC. For you to make a finding, for you that, the first finding that you have to make, there is, first, the people who hold public office, they hold what we call RETAC relationships. These are relationships of trust and confidence within our constitutional architecture. Relationship of trust and confidence within our constitutional architecture. So you have to make a finding first. There is a property in public office, okay, number one. And that confidence is to the Constitution, number one. You have to make a finding. There is a property to holding public office, okay? Even when there is a breach of that trust. And a finding has been made by other organs of the Constitution. And the court, the test has always been threefold. Number one, total interference, judicial fiat. And we don't do that, our courts don't do that. Courts don't substitute their preferences to what other organs do. The second aspect has been total deference, not to what other organs do, but total deference to the Constitution. And this is very funny. Professor Githu Muigai is here. I used to teach first year contract, and the case of Feldhaus versus Binley came to mind, that the Constitution is silent, so that means that we can read into things, or we can tell the court to intervene. The Constitution is silent on the court intervention under 149, so we read into it. So that's the second aspect. Total deference, if there is a constitutional injunction, constitutional mandamus, against a public body or against this court, then the court should be able to deal with that. The third one is the intermediate test. And this is what the court has applied, Your Lordship. The intermediate test is you do procedural constitutional compliance. This is our authorities in E181, Justice Majanja's judgment in the Finance Bill Act. In fact, the decision of the Finance Bill Act Supreme Court came down a few hours ago. I think we provide to the court should look at it. The threshold for public participation is not PAG, by the way. The threshold for public participation is even lower because of that decision. And when you look at that decision, which we have provided to the court does what we call procedural constitutional compliance. And what is that? You look at whether a vote happened and the threshold within the constitution have been met. No more than that. And that is supported even by the decision of the Supreme Court, which came down just a few minutes ago. And I want to read a small excerpt, Your Lordship, on that decision, which we have provided to the court.
Which one are you talking about?
I'm talking of the, it is Your Lordship, the citation is E031 of 2024, consolidated with E032, E033 of 2024. Came down just a few hours ago. And I will just refer the court.
How is it reported?
It is reported as E031. Let me just, I'll get, it's not yet, no, it's not yet reported, but it is petition number E031 of 2024, Cabinet Secretary for National Treasury versus Okia Omtata.
Petition number?
E031 of 2024, as consolidated with petition number E032, E033 of 2024, Okia Omtata, the Cabinet Secretary for National Treasury versus Okia Omtata. I argued that, but I was led by Professor Gidu Muigai. Mr. Ochiel Dudley is there, he can rebut, but he was part of those proceedings. So the threshold is even lower for public participation, number one. That is something that the court has to look at. But importantly, what did the court say about interference at paragraph 208? And I will end here, Your Lordship. Paragraph 208, the Supreme Court of the Republic it quoted the case of International Trade Administration Commission versus South Africa, and this is what it said. I'll just read a small excerpt. Where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. I think that is good law for you. It is a direction to you. And if you look at that case, if you look at Peter Munya, if you look at the nugatory aspect, and if you look at the fact that there is at what the submissions of Hussein Marjan and our submissions, you will find there is an express constitutional injunction against interference, not only for this court, even against IEBC. Because if you told me this is an election you are able to clear, then I'll tell you, how am I supposed to conduct this nomination process? And what are the constitutional orders flowing from that? Your Lordship, our submissions are sufficient. I am being told to step down, but thank you so much.
Who has told you?
Oh.
Who has told you to step down?
I was being told by Professor Gidu Muigai. My professor is telling me to step down. But if I can, just a second.
It's okay, you can step down.
Yeah. Not the court, but Professor. But our submissions are those ones, they are on record. And even if there is a role to be played by IEBC, our position is those are administrative roles, which we could still play. But, and that is provided for under Section 11 of the IEBC Act, Section 13(1) of the IEBC Act. The role that we have to do under 137 is to check the voters register. And we check voters register for even people who, for Kenyans every other day, it's a public document. There's no role for the IEBC to play. And if the court were to make there was a role for us, then we say those are administrative roles. But the court should not find a role for us.
Please supply authority you have quoted of E031 to E033 of 2024.
I will. It is hot off the press. I will submit it just now.
Submit to our assistants.
I will, Your Lordship. Thank you so much for listening.
My Lord, I want to apologize if I appeared to take judicial discretion from you. It was intended to keep my promise to you that we will be brief.
We now get to know that every side has a prefect, and at this side, The prefect is Professor Gitu.
My Lord, I just want to also add my voice to the submissions that have been made by the respondents. And they should go on record as that my name is Shara Mose, the Solicitor General for the Attorney General, together with Professor Gitu Muigai and Charles Mutinda and the rest of the team. Yes, my Lord, to say one or two things so that we wrap up submissions from our end. My Lord, it is not in contestation that under Article 145(7) of the Constitution, a final decision of impeachment was made. It is not in doubt, and that has not been controverted by either side.
No, we have. That is what we are challenging.
A final order, at least, my Lord, was made. Secondly, my Lord, it is also not in contestation that a vacancy has arisen or arose in the office of the Deputy President. It's also, my Lord, not in contestation or in doubt that Article 149 of the Constitution was invoked in terms of the President nominating Professor Abraham Kithure Kindiki as a nominee to that position, and that Parliament voted on the same. And I would agree with my learned colleague who has just left the floor, Mahat, that the framers of this Constitution never intended that the IEBC plays a role when it comes to the issue of impeachment. And my Lord, if they so intended, nothing could have stopped them from expressly stating that position. And therefore, my Lord, I am submitting the interim orders that were granted and are in place cannot cure that position. And therefore, my Lord, relying on the various authorities that have been cited, and more particularly, my Lord, the Munya case, which is a classic case in terms of what will be required in the grant of conservatory orders. It is my humble submission, my Lord, that that has not been made. And I would also submit, my Lord, that when you look at the greater public interest, my Lord, we want to persuade you with the very many other arguments that have been given by my learned colleagues, that you will find favor that the discharge, the vacating, or the varying the orders that have been in place would find greater good than holding those orders in place. And therefore, my Lord, to conclude, I would urge my lady and my lords to find that we cannot continue holding the country at ransom. We need to make a decision that some of the roles and the responsibilities that are played by the Deputy President, which are currently at a standstill, would be extremely good and critical that the moment these orders are vacated, the rest of the processes should be allowed to be completed. I therefore humbly submit that you discharge the orders that are in place and allow the entire process to be completed. I submit, my Lord.
Thank you.
My Lord, I want to confirm on behalf of the respondents that we rest there, but with your kind indulgence, if there is to be a reply, I think again we need to remind ourselves that it ought to be on points of law. If the case is rehashed afresh, we would still be here tomorrow and it would contrary to procedure.
My Lord, I also request a direction on whether persons who are not parties to the application, because there are only 2 applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Okay, 2 things.
Why are we being preempted?
No, two things on way forward. I think we still have to hear interested parties, or have we had them? Anybody? We finished with Dola. Yes, now, the right to rejoinder is only limited to the applicants and not any other person supporting the application. So it will go only to the applicants. And in this case, we have 2, and they will have, how much do you need?
You had given us 30 minutes, if I remember. I am addressing the court, please. Yes. Reply to the court. You had given us 30 minutes.
My Lord. Do we do 15-15 or 20-20?
No, my Lord,
yes.
There is a lot that has been canvassed. In fact, they had given us the impression that they will need less than an hour. They have obviously done 4 hours and something. No. There was things that we
okay, let us have on time.
We can do within 30 minutes. Or less, depending on how much he's able to cover. The only issue, my Lord, that is the mischief, is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business, and we go.
Okay, this is the way forward. We will give the respondents the time they need. 30 minutes each. Not the respondent, but the applicant. 30-30. Let's go.
My Lord, may I please the court?
Yes, on what issue?
On the same issue, because I've been standing and I didn't catch your eye. Still on the issue of the right to reply. My lords, you might remember that I am, first of all, I am one of the unrepresented petitioners in petition 11. And for the my lord, you might remember that for the last 2 weeks when this matter has been being handled, I have been insisting that we made an application for conservatory orders prior to even the applications we are discussing now, and it was in the best interest of all of us that when discussing the conservatory applications, we be treated as respondents. My lord, unfortunately, when the court gave directions, it consolidated all the petitions, but did not give directions on how our applications would be heard.
Now, Mr. Bosso, just a minute. We will restrict ourselves to the applications at hand. So if yours is not among the 2 applications, then you may have to address that later, not now. And the rejoinder should be on points of law. Yes. Rejoinder should be on points of law.
My lord, I stand guided, but I'd still wish to point out that there are very specific issues that I raised that were not raised by the other applicants, and which the other side has responded to, and would leave the issues unresponded to altogether.
You can pass those submissions to the to their counsel, appearing for the other applicants.
Before counsel proceeds, I am Wangi Munga, counsel for the 43rd petitioner, Mr. Moraro Moke, and we also had an application which we believe we have a right to rejoinder, a brief rejoinder. And it was one of the applications that was canvassed. So we also have a brief right to rejoinder. Will only take 5 minutes.
My lords, Morara appeared in person and argued his own case.
And I am his counsel.
It is not possible.
We appear together with him in this matter.
Let us give directions, and we will proceed with these directions, which my Lord Judge Mrema is going to give. There must be order in every proceeding.
Who is starting? Is it Mr. Yes, proceed.
My Lord, my name is Ochiel Dudley, and it's a great privilege and honor for me to appear before you and to make the Deputy President's rejoinder. Ochiel Dudley is my name. My Lord, allow me to begin with where my very good friend Mr. Somane stopped. I think he intended to cite to you paragraphs 209 and 210 of the Supreme Court decision. He stopped at 208. I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court has said this afternoon, that the framers of the Constitution made it possible for litigants, like our client, the Deputy President, without exception, to approach the courts for redress of fundamental rights and on issues concerning interpretation of the Constitution to determine whether any law or anything said to be done under the authority of the Constitution is constitutional. Paragraph 210, Supreme Court, this afternoon, the court says that this constitutional inquiry, the inquiry you're involved in, extends, the court, while conducting this inquiry, should bear in mind the unlimited reliefs contemplated under Article 23. My Lord, that's sufficient to clear any doubts about your jurisdiction and to clear any doubts about your power to give conservatory orders. If there are any doubt, the court should now feel comfortable. My Lord, during the break, I inquired from my learned friend, Mr. Thiankolo, a very good friend of mine, and I asked him, Dr. Thiankolo, who is the governor of Meru County? He told me, Kawira Mwangaza. Then I asked him, by what authority?
Is he still submitting on points of law, my lord?
You want to hear?
When I asked him, by what authority, he told me, by a conservatory order. And so, my lord, this court can give conservatory orders against impeachment. The conservatory order we are speaking about, the one I was speaking to my colleague about, was given by this court not so far ago, on the 21st of August, 2024, in petition E429 of 2024. Let me come to the other case, the Kisii governor's case. My Lord Justice Ogola, you are familiar with that case. You're not a stranger to it. Because at some point you gave directions indicating that you would not interfere with the conservatory orders in place and that that matter would come before Justice Okwany, which is a decision my learned friend, another good friend, Mr. Nyamodi, spent a lot of time on. My Lord, that case is different from this one on the issue of delay. Under Section 32D of the County Government Act, a vacancy in the office of Deputy Governor must be filled in 14 days. What did Purity Mora Kirera do? She filed her petition on 1st of April 2024. The Senate impeached Dr. Robert Monda on 14th of March 2024. So she was coming to court outside the 14 days. My Lord, in this case, we have 74 days under the Constitution, Article 149(1). Those 74 days have history in the constitutional text. My Lord, if you look at page 233 of the CKRC final report, you find Kenyans speaking about, my Lord, the need to allow the transitional processes to be disputed. My Lord, the Constitution gives a lot of 14-day timelines, but in this case, it gives 74 days. And we submit that the purpose of that is to allow aggrieved parties to come before the court like we have. And so, my Lord, on the issue of delay, which is a distinguishing fact, which is why the court did not give Kirera conservatory orders, but gave Mwangaza conservatory orders, is that the 14-day period had expired when the petitioner went to court. My Lord, allow me to concur fully with two things that my learned friends, Mr. Nyamodi and my good friend, Mr. Somani, said, that conservatory orders are really for the court, because the court has a duty under Article 23 to fashion appropriate reliefs. Conservatory orders, as they said, help the court to preserve a matter. And the matter to be preserved here is an impeachment both at the National Assembly and the Senate, and the subsequent nomination of Kithure Kindiki to the office of Deputy Governor. And again, unlike Mora, he is yet to take oath here. So the subject matter before the court is still live, and you can and need to preserve it. Lord, on the nature of conservatory orders, I agree fully with the submissions of the Attorney General. The case they cite, TSS spinning, helps the petitioner more than it helps the respondent. Because in TSS spinning, the court says that conservatory orders, as tools for preservation of the subject matter, hold the subject matter in situ. They maintain the situation of the subject matter before the mischief crept in. The mischief crept in here when Mwengi Mutuse filed his motion. So the conservatory order preserves that state of affairs. It takes us to the point before the mischief crept in. More mischief will creep in if, despite this litigation, Kithure Kindiki is sworn into office. My Lord, other cases we agree with, cited by the National Assembly's Kitale Industries, helps the DP on the point that conservatory orders are tools for preservation of a particular state of affairs. The particular state of affairs, which so far you've preserved, is that our client is a deputy president of the Republic of Kenya. We ask you to sustain this conservatory orders. My Lord, County Assembly of Embu, argued by the Supreme Court, is distinguishable. In that case, the Attorney General told the Supreme Court that if a vacancy occurs mid-term in the office of Deputy Governor, then that vacancy would remain to the end of the term. The vacancy, paragraph 28, County Assembly of Embu, the Attorney General told the Supreme Court would remain to the end of the term. It would remain unfilled. That time, we had not yet amended Section 32, capital D of the County Governments Act. It was amended in reaction to this Supreme Court case. And so the Supreme Court, to that suggestion by the Attorney General, says that no, we cannot have an indefinite vacancy in such a vital office. That case is distinguishable. I reiterate that the timeline we have here is 74 days. We're yet to eat into a quarter of those days, my Lord. And from the posture taken by this court, it's possible to hear this case and conclude it within those 74 days. My Lord, this petition, within those 74 days, all the three chains of Kenyan's court, when required, have risen to the occasion. BBI did not last the 3-5 years my friend Mr. Thiankolu spoke about, it lasted a matter of months. And so it's possible for this court to hold things in place and to expedite the main petition. My Lord, unless that happens, my becoming friend, Professor Githu Muigai, spoke about the dissipation of the subject matter. He said this has already dissipated. My friend, Professor Jenda, said, likened it to a death which has already occurred, and so there's no coming back from it. The Senate, in their submission, suggests damages. The petitioner has not pleaded for damages. In short, my Lord, if at this stage the respondents can tell you that the court cannot craft remedies, Dr. Thiankolu bases his preliminary objection on that point. He says that you should not touch this dispute because you would not be able to craft any remedies after hearing the case. My Lord, if at this stage, before you hear the case on the merits, you can be told that, what would happen when, without conservatory orders, you hear the case and the petitioners succeed? My Lord, as I move to conclude, the Attorney General urges you to find, on the basis of the vacancies in the IEBC, that there's public interest in allowing the process to conclude. My Lord, there is an authority, a court order by this court in proceedings to which the Attorney General was party. The Attorney General, in January of this year, 26th of January 2024, in the Banisa case, the Abdullahi versus Attorney General, was directed to reconstitute the IEBC. He has not done that. Today, the Attorney General stands before you and tells you that on account of his delict, on account of his and his client's contempt of court, you should exercise your equitable discretionary remedy of conservatory orders in his and his client's favor. My Lord, a party cannot benefit from their own wrongdoing. That fact of vacancy in the IEBC against an order of this court should not be evaluated in favor of the Attorney General and to the disfavor of the petitioners.
Mr. Dudley.
My Lord.
Are there any pending litigation on the IEBC constitution?
There are, yes, my Lord, but this order has not been stayed. It has not been appealed.
That's okay.
Yes, my Lord. My Lord, there's a case that we did with my good friend, Mr. Adrian Kamodo. It's called Itumbi versus Law Society of Kenya, where Justice Ongudi gave directions and orders to maintain the status quo pending the determination of the matter in court. Itumbi, through my good friend Adrian Kamodo Njenga, went to the Court of Appeal. The Court of Appeal, my Lord, affirming those orders, found that it was an act of mischief to ask the Court of Appeal to vacate conservatory orders meant to preserve the status quo pending the hearing of the matter in court. We submit that the application to vacate made before you is an act of mischief. There's another case, my Lord, on this issue of vacating conservatory orders. This case was argued by my good friend, Mr. Nyamodi, when he was still on the good side of things. And Professor Githu Muigai was also in it. Those days, Nyamodi was a good guy. He had not joined the bad company of Mr. Gumbo, who is my friend. My Lord, this is what the Court of Appeal said. The Court of Appeal said that...
My Lord, he must be a bad guy if Gumbo is banded with his friend.
The Court of Appeal said, my Lord, that when weighty challenges have been placed before you, before a court, and the court has issued conservatory orders, one requires a very strong case to lift those conservatory orders. My Lord, a very strong case has not been made before you to lift the conservatory orders. Instead, a very strong case has been made to sustain and to affirm and to reiterate the conservatory orders. My Lord, I close with the issue of public interest. And again, thanks to the doctrine of precedence, you do not have to think too hard on this. In Attorney General versus Matindi, shutting out 50 CISs whose appointment was questioned before the Court of Appeal, my Lord, said that it would be no consolation to tell the Kenyan people that although service has been rendered, although unconstitutional service had been rendered, it's still service. The Court of Appeal said, my Lord, that service in violation of the Constitution is no service. And in a case that Professor Ojenda argued, the Ong'o case, when
I didn't cite that.
I am citing it, well, I am citing it in my reply.
In response, although I thought on points of law, you refer to cases that have been cited by the other side. I did not. You can't pick up my case. I didn't argue it.
My Lord, if he didn't argue it, he should have argued it. This is a point of law. My Lord, you are told about the public interest. The Court of Appeal in Ong'o.
I think you should respond to a case which has been cited, because otherwise he'll also have the right of reply, and we'll be here for a much longer time.
Back and forth. Just leave
My Lord, if that rule held true, my Lord, how would we have, for example, presented to you the Supreme Court President? Because the purpose of rejoinder as well, my Lord, is to distinguish and to tell the court points which the other side have concealed.
Well, say it, then we'll give him a right of reply on that issue.
It's in our submissions. It is.
Do you accept that we'll give him a right of reply on that issue?
On this case, yes, my Lord, because it's in our submissions.
Okay, proceed.
The Ong'o case is in our submissions, my Lord, and he can distinguish it if he wishes to. My Lord, the court said, in short, that it is in the public interest to keep out a person if the validity of the appointment is questioned. He had wanted his client to assume office despite a court order to that appointment. And so, my Lord, the office here is a high state office. If Kithure Kindiki assumes office, he will make directives, he will make policies, he will commit omissions. My Lord, this court is yet to design a mechanism for reversing the policies, the decisions, the directives that you would make. If at the end you find that the impeachment and the nomination were both unconstitutional, the Constitution would have been irreparably violated. And my Lord, I close on the point that this case is arguable. In fact, the courts had to stop Mr. Milimo many times and was lenient to many others of my colleagues who strayed into the merits. Prof. Ojenda being at the forefront of that. The council argued the merits on both sides of the aisle, my Lord. And so, my Lord, that demonstrates that parties are biting at the bits. They are ready to argue the petition and would do so at the earliest opportunity. We request you, my Lord, to allow the request for conservatory orders to please preserve the dispute and let our appearance, our further appearance before you be of some meaning under the Constitution. Thank you for the opportunity, my Lord.
Thank you.
My Lord, may I donate, if I still have it, 3 minutes to my colleague, Mr. Ogala, to say a word.
Lordship, I will be brief. I want to respond to the following points of law raised by the other side. From the other side, a lot of hue and cry has been made about Article 145, subclause 7, and the word shall. Your Lordship, the Black's Law Dictionary, Brian Garner, 10th or 9th edition, confers 6 different meanings to the word shall. So from the plain text meaning of the word shall, The dictionary in law gives it 6 meanings. So shall cannot only mean mandatory. It can mean any other thing. Black's Law Dictionary. In terms of the reading of the Constitution, the Constitution can be read multiple times. It's not only the textual reading of the Constitution that counts. If I had time, I would share with my friends that we drink uji once in a while on the other side. There's a book by Professor Philip Chase Bobbitt that canvasses 6 methods of reading the Constitution: textual reading, moral reading, structural reading, doctrinal reading, purposive reading. Purposive reading has been read in our Constitution, Article 259(1). It has about 4 elements. If we go to 259(3), living tree reading, first articulated by the case of Edward versus Sankey, 1930 Canada. What does that mean to this honorable court? There's more coming. So while they were telling us that we are running away from the case, we're telling them, Ngoja, bado mambo, we are ready. And we are going to explore the full depths of this Constitution on the merits. Please conserve the substratum. We are ready to go. The question, another point was raised here, that the President is protected by the Constitution in his role in appointing a prophylactic Deputy President in a nominating capacity, nominative capacity. The Constitution in that manner is deemed as a constitutive charter. It creates institutions. The Constitution, going by the violations that have been raised on this side, touching on constitutional rights, plays a protective capacity. So this court will, on the merits, be asked to balance those 2 shades of the Constitution. The Constitution as a constitutive charter, the Constitution as a protective charter. We will discuss that on the merit. My good friend, Senator, Professor Tom Ojenda, expert orders need to be lifted for the reasons he raised. They have not answered to you, to your satisfaction, and we attached a case in our submissions. There's a decision of the Ghanaian Supreme Court, Barclays Bank, in our submissions. The test for overturning a decision made ex parte, they have not satisfied you as to why the decisions of Justice Mwongo in Kerugoya should be overturned. The issue here is broader than mere compensation by way of sums of money to an individual. The broader question here is the Constitution and how offices of the Constitution are occupied. Article 1, Article 2, Article 3 of the Constitution. My good friend and teacher, Mudomi Thiankolu, that there is an absence of a specific textual authorization for judicial involvement in the court. Again, we refer to the various methods of reading the Constitution, such that if we go by their own arguments, and I had my good friend Mr. Somane talk of reading in, there's a remedy available to this court under Article 23. Reading in can be read into statute or any other constitutional methods here. We can use that as a remedy. So the absence of express textual bar in the Constitution does not preclude this court from reading the Constitution in any other way. Several documents are cited here, the Bomas draft, the Kilifi draft. What was missing from all that discussion is the commentary from individual delegates. Because if we were to look at the travaux, the preparatory documents, where are the comments from the delegates? Where is the report on for the committee of experts? And in any case, the Constitution 2010 enjoys its imprimatur, its force in law, by the seal of approval it was given by the citizens through a referendum in August 2010. And any law interpreted and read into the Constitution post the promulgation that becomes law. These courts have been laboring to do that for some time. Finally, Mr. Milimo, the Senate sits in a quasi-judicial capacity. Yes, if the Senate sits in a quasi-judicial capacity, Article 47 kicks in. This court has to exercise judicial review. Madison versus Marbury, 1803. It is inherently the province of the judicial branch to say what the law is. I submit.
Thank you. My Lord, for purposes of the second application, Mr. Ndegwa will, in about 5 minutes, will make some 2 points, then I will proceed with the remainder.
Thank you very kindly, my lords, my lady. Permit me just to indicate what Professor Githu Muigai Senior Counsel indicated, that the Senate is a chamber or is a political chamber. There can never be something that is far from the truth, because in the case of Governor Wambora, that is civil appeal number 21 of 2014, the Court of Appeal had the opportunity of evaluating that preposition, and it came to a conclusion that when the Senate is seized of a matter of impeachment, it's not just a political chamber, but it converts itself into a quasi-judicial process. And that is why, my lady, my lords, under Standing Order number 79, the Senate is required to take a special oath before constituting itself into a quasi-judicial chamber. On the question, one issue of about justiciability of the process, it's our humble submissions, my ladies, my lords, that was ousted by the enactment of Article 3, Article 1, Article 10, 27, 25, 50, 165, and 159 of the Constitution. When the people of the Republic of Kenya enacted Article 3, it bestowed upon all state organs, any individual, to protect the Constitution. And therefore, there is nothing that is far from the reach of this court, insofar as the protection of the Constitution and Article 3 is in issue, insofar as the upholding of the doctrine of sovereignty is in issue, insofar as the application of Article 10, the principles of and the values of governance are concerned, and most importantly, the rule of law. How can it be that justiciability can be pleaded as a defense, yet the court is being told to uphold the rule of law, good governance, democracy, and the participation of the people? How can it be that this can be a defense when Article 165, 3D, calls upon this court to interrogate whether anything said to be done has been done in accordance to the Constitution? Was the impeachment of the Deputy President not done within the Constitution? Was it not sanctioned by the Constitution? How then can it be from the reach of this court? How then can it be a defense when Article 27 creates a doctrine of equality before the law? How can it be argued in that respect? Allow me to address what Professor Ojienda addressed. The question of the two-tier trial. Yes, it was a two-tier trial, but was the Deputy President granted an opportunity to be heard? My Lord, my ladies, look at Article 1 and Article 94 of the Constitution as read together. Article 94 provides for the creates Parliament and provides that it's a representation of the people. How can it be a representation of the people and you lock them out when it comes to their participation on a question of the impeachment of the Deputy President? How can it be that Parliament can be immune from the application of Article 1 and usurp the people's power when the people are supposed to directly participate in giving their views under Article 118 of the Constitution? My ladies, my lords, you are invited to look at the trial at the Senate, and you are told that it was time-bound. My ladies, my lords, it's a misconception and misreading of the Constitution under Article 145. My ladies and my lords, the only time Senate was limited was when or if it constituted itself into a special committee. If what transpired in Parliament, in the Senate, was a matter that was under Article 145, Clause 6, then we could say that the 10 days period mattered. But it is important for us and imperative for us, my ladies, my lords, to note that when the Senate sat to hear the impeachment of the Deputy President, it is sat as a plenary of the House. And as such, the 10 days were not therefore applicable in that circumstances. Number two, my ladies, my lords, you have been told that the Deputy President avoided to appear for his defense and that he was represented. But my ladies, my lords, if my good learned friend professor was carried with the truth, he would have drawn your attention to the provisions of the rules of procedure for the removal of the president and deputy president, starting order number 78(9), and he would have drawn your attention to rule number 6. And on that rule number 6, he would have told you that the rule provides that where the president chooses to appear before the Senate, the president shall be required within 3 days of the invitation under sub-rule 4, or rule 4 on the date specified in the invitation to file an answer to the charge with the office of the clerk of the Senate in which the president shall set out. He would have told you the mode of appearance. 1, the president's response to the particulars of the allegations. Number B, how the president, and in this case the deputy president, proposes to appear before the Senate. And that rule has created through mechanisms or through 3 ways in which the deputy president could have appeared. 1, whether in person. 2, by advocate. 3, in person and by advocate. The operative word in our case, my ladies, my lords, is number 3, in person and by way of advocate. The deputy president appeared in person and by advocate. And as such, my ladies, my lords, when he was taken ill, the question of then appearing in person and by advocate was an issue. And number 2, my ladies, my lords, he was a witness and the only key witness before the Senate. How then could you say that there was fair trial under Article 50 of the Constitution when the only fundamental infrastructure of the trial is unavailable? My ladies, my lords, permit me to address you on what was submitted by Mr. Somane. It's unfortunate that he has chosen to have a very lean and thin way of looking at the application of Article 149 of the Constitution. There can never be anything that is misleading to say that that article should be read in isolation of other provisions of the Constitution. If you choose to read Article 149 in isolation, you arrive at the absurdity that Mr. Somane and his colleagues have arrived at. I would urge this honorable court to look at the import of Article 259 of the Constitution, which provides for the manner in which the Constitution must be interpreted. If Mr. Somane was carried with the truth, he would have invited this honorable court to harmonize and to purposively read into Article 149. My ladies, my lords, the reading of Article 149 in a purposive and in a harmonious way would have told Mr. Somane that then Article 99 and Article 137 of the Constitution is imperative. And therefore to say that the IBC had no role in the process of the nomination of Mr. Kindiki is absurd, is not true. The fact is that if Mr. Kindiki was to successfully become the Deputy President of the Republic of Kenya, is it then true that he can become a Deputy President who has not qualified under Article 99 of the Constitution? Is it therefore true that he can become the Deputy President if he has not qualified under Article 137 of the Constitution? Who then determines this qualification? Is it the President Is it Mr. Somane? Is it I Ndegwa? Who determines that qualifications if it is not the IBC?
My Lord, there is something that Mr. Jiru is submitting on, which touches on very critical facts concerning Professor Kidiki as to his qualifications. And we are all familiar with the qualifications of Professor Kidiki.
I think the last time Mr. Kamodo was before you, he said he has no client.
I have a client, the 10th respondent, the United Democratic Alliance. I ceased to act for the other client because it would have been illegal. But I have a client. So I'm properly on record. And it is important that the record be made straight with regard to Professor Kidiki's qualification, and including what had been cited in the affidavit that he was not a member of the UDA for 3 months, which is not a requirement in law. No law requires you to be a member of a political party for 3 months for you to ascend to the position of the deputy president, which Professor Kidiki has acceded to. And secondly, it will be...
That's a merit issue that is being argued. So are we going to have the opportunity to answer it? Because the law is the opposite of what you say.
It was raised by Mr. Jiro. I'm just clarifying, and then Mr. Jiro will continue.
To raise that issue, that is my submission, my lord. He is going into the merits.
But then Mr. Jiro may
just let's sort it. My lord, it's me who is on record for Professor Kindiki. I think if Mr. Degwanjiru, my very good friend, I usually call him the Black Bull, could keep off rehashing his application.
The black what?
Bull. That's what Degwanjiru means. If my friend, the Black Bull, could keep within the remit of a rejoinder and a reply, we will not be having all these interjections. I've been resisting the urge because I always try to avoid appearing cantankerous. But if he keeps rehashing his application, unfortunately, then as the person on record for Professor Kidiki, I will be forced to be cantankerous, which is not my nature.
Let's give Mr. Njiro time to finish.
I am also obliged, my lords. My lords, finally, let us distinguish the Kisii case from what is before you. What is before you, my ladies, my lords, is a case where a party was not granted an opportunity to be heard. It is a question where there is a violation of Article 27, violation of Article 10, violation of Article 50, and violation of Article 25, that the right to be heard cannot be derogated. What was in Kisii, my ladies, my lords, is that the Kisii deputy governor underwent the full trial at the Senate. And therefore, my ladies, my lords, those facts are distinguishable. Finally, my ladies, my lords, Mr. Gumbo urged you to fight that there will be crisis if the position of the deputy president is not filled. I want to remind him that Article 139 and Article 146 has created an avenue and a remedy where if the president is even today impeached, the remedy is that the Speaker of the National Assembly under Article 146 takes over for 60 days, and under Article 139, if the two of them are not able to take office, again the remedy is that the Speaker takes over. So we are not in a crisis whatsoever, my ladies, my lords. I invite my learned friend, Senior Mr. Kibe, to proceed.
My Lord, I start with the assurance to my learned colleagues that I know what is reply to issues of law. So I hope I can proceed without a lot of interruptions. My Lord, I start with the submissions by my learned colleagues, Professor Muigai. I agree with him, my Lord, that you cannot be able, we are entitled to a legal opinion, but we are not entitled to a set of facts. And therefore, where the set of facts is as they are. But my Lord, in saying this, it is important to remember that what also litigants are not entitled to, and this is the reason for conservatory orders, is the fact that, unlike in war, where you can change facts on the ground. The court looks, the court does not accept a situation in which one party would be allowed to change facts on the ground in a manner that makes a mockery of the proceedings before it. That is to say, if we are before you on account of the fact that there have been violations in the impeachment process, my lord, and the conservatory orders that have prevented the completion of those illegalities are in issue, this court should not permit a situation in which a party is able to say that let me change certain facts, as it were, by completing the violations. My lord, there is a question of public interest. We don't have to say much about it, but coming from the Honorable Attorney General, my lord, I would only urge that public interest from the Attorney General must also be read, apart from what is directly friendly to the government, must also be read to what is also friendly to the people of Kenya. And that is a desire to ensure that the impeachment process is done credibly and upholding all the rights and the procedures that are in issue, so that it is still possible for the Attorney General to say that public interest in this particular scenario would require that fundamental rights, the case on fundamental rights, be concluded before you can be able to say this or the other person should take office. My lord, there is the issue of the conservatory orders. I've had to read them again. The one from Justice Muongo, because they have been called as orders of reinstatement or mandatory injunctions. My lord, I believe, and I have a lot of full confidence in the fact that it will not be possible for Judge Muongo to issue mandatory injunction on reinstatement at that level, and as a matter of fact, he did not. The prayers as framed is purely to preserve this matter pending hearing a determination of the petition. So it's a scarecrow argument to say you are seeking reinstatement, you are seeking mandatory injunction. There is no such thing, my lord. Coming to Professor Ojienda, he said many things. There are only two that I wish to respond to. One of these is the observation, his reactions to the fact that, to the Senate process and about the Deputy President. My lord, I wish and I hope the court will note the substantial lack of empathy in the circumstances of the Senate about why the DP was not there, what remarks ought to be made, and what ought not to be made. Second issue that we wish to make with regard to the issue of Professor Ojienda is, of course, this issue that he said there is no comeback from impeachment and all this, and we proceed and swear. My lord, if that were to be the case, then it would mean that impeachment is not the legitimate subject matter of this honorable court. Yet we have had the decisions that they have read themselves from the Supreme Court on the issues of impeachment. My lord, Mr. Muthomi Thiankolu, my friend, came with these interesting arguments that on the issues of jurisdictions. My lord, these issues of jurisdiction is an interesting one, as you will see it in a minute. My lord, the first impeachment case that appeared before a three-judge bench was in Kerugoya. Kerugoya seems to favor a lot of impeachment stuff. And it related from the Embu cases. I don't know whether Professor Ojienda was there. But my lord, it is important to say this with regard to that I actually made the precise argument that my learned friend Mr. Mugobi made about whether the question of impeachment under the constitutions of Kenya was justiciable or not. The three-judge bench held that it was justiciable, and it is on the basis of that because it relates to the issues of Bill of Rights and procedure.
My lord, let him also tell you whether it was the impeachment of the president, because my submission was not that impeachment is generally non-justiciable. Even the authority has cited it was about the impeachment of the president, whether that is justiciable.
I'll come to that in a minute. But the point I want to make For purposes of the argument, the authority is there. For purposes of the arguments, those precise arguments were made. There is actually no distinction when you look at the impeachment for governor under 181, how it is carried out vis-a-vis the one of the president. But one of the significant position that I wish to make from that case is this, that subsequent thereto, all courts from Court of Appeal to Supreme Court have taken the position.
Enjoy StarTimes Sports all month long. Buy a StarTimes decoder at our business halls or dealership countrywide to experience passion from the heart of Saudi Arabia's most electrifying football league.
This is absolutely wonderful!
Renew your subscription today. The thrill of every La Liga goal. The intensity of every Bundesliga match.
Coming down!
Feel the passion, the power, and the pride of world-class football as the best teams battle it out for the sound of victory. Renew your subscription today. StarTimes. Enjoy digital life.
Colgate Herbal is formulated from a unique blend of natural herbs, scientifically proven to strengthen teeth and keep